Well, welcome to the show. I am your host, Daniel, and today is Judge George Mertz's courtroom. In cases being heard in Judge Mertz's courtroom. So let's get started with this.
Okay.
I'm trying to adjust that. Make it bigger. And
5480. The record should reflect Mr. Witt's present during the courtroom today.
Thank you. We do have a plea offer from the prosecutor. It's Mr. Witt pled guilty to count 1, resisting or obstructing the police officer, and count 4, operating while intoxicated. The prosecutor would dismiss counts 2 and 3, which are also resisting counts, and would also dismiss count 5, which is open intoxicant in a motor vehicle.
Okay. Ms. Koch, is that a correct statement of the plea offer?
It is a correct statement of the plea offer, Your Honor.
Mr. Witt, have you had an opportunity to speak with Mr. Thompson about this agreement?
Yes, I have.
Is that how you wanted to go forward today?
Yes,
You raise your right hand, please. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
yes,
Thank you. Mr. Witt, are you currently on any kind of probation or parole?
no,
You understand that by pleading guilty to count one, which is resisting or obstructing a police officer, that's carries with the maximum possible penalty of up to 2 years and or a $2,000 fine,
yes,
and that operating while intoxicated as a first offense carries with it a maximum possible penalty of up to 93 days of jail and or a $500 fine.
yes.
With those two maximum possible penalties in mind, what is your plea to each of those charges today?
I'll take the plea deal. I'd like to do the plea deal.
You're gonna
So the
plead
judge is
guilty.
asking, I'm sorry. Go ahead.
You're gonna plead guilty.
Yes,
Okay. All right, I'm gonna go through your rights with you here this morning. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf if you're at trial. You have the right to remain silent during a trial, to not have that silence used against you. The right to testify at the trial yourself if you want it. Do you understand all those rights?
yes, I do.
You understand that you're giving up and waiving all of those rights by pleading guilty.
Yes,
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal, you can only do that by leave, which means you have to ask for the Court of Appeals to hear your case. They could say no, then that would be the end of any appeal. You understand that?
yes,
Has anyone threatened you with anything to get you to plead guilty?
no,
Has anyone promised you anything other than what we've said here in court today?
no,
So you seem unsure about that. Is there,
it's my first time. I really, I kind of don't know exactly what I'm doing.
okay. So what I'm trying to just make sure is that, number one, nobody's threatened you, so you're not being forced into entering this plea.
All right,
And I also want to make sure that, other than what we said here today about the plea agreement, that nobody's promised you anything else, like, you're going to get something in return for entering this plea, or,
gotcha.
you know what I mean? There haven't been any other promises made.
No,
Okay. Is it your own free choice to enter this plea?
yes, it is.
And are you pleading guilty to these two crimes because you are actually guilty of them?
Yes,
So this happened back on August 14th. Is that the correct time frame?
yes, it is.
That was this year, 2025.
Yes,
On that date, had you been consuming some alcohol?
yes,
And after you consumed that alcohol, did you operate a vehicle on M72 here in Crawford County?
I did.
And how much alcohol did you consume before you drove?
I want to say I had 9 beverages before I left the house, and then, definitely I drank more on the way up.
Okay.
Shouldn't have done it. I messed up pretty big, but
So when
no,
you say
I,
the house, are you talking about your home in downstate?
yes,
And then you were consuming alcohol to drive up?
yes.
Did you have any blood or breath tests to determine the level of alcohol in your system?
Yes.
Was it above a .08
Well,
legal limit?
I haven't received my blood work back yet.
Had you consumed enough alcohol that you believe that it prevented you from safely and normally operating that vehicle as you would if you were sober?
I think, I had a certain level or certain aspect of drinking, obviously drinking slows you down some, your reaction time goes up a limit, so I mean, yeah, I shouldn't have been driving.
Do you believe you had consumed enough alcohol that you were intoxicated at the time you were driving here in Crawford County?
Yes,
And did you come in contact with a police officer during the course of that incident?
Yes, I did.
And did you know that that police officer was there performing his duties as a law enforcement officer?
Yes.
And what did you do to resist or obstruct that officer in his duties that day?
We started off, so I guess we got over to the car, I had my hands on the car. I started collecting my stuff up. And I guess when I reached for my keys, he came in and, pushed me onto the hood of the cop car. So as soon as he was arresting me, I got a hand injury. So when he reached for my hand, it hurt my hand. I jumped out of my shoes because it hurt. And when I jumped up like that, I didn't realize I jumped as much as I did. And he took it as I was resisting. So two other officers then came in. They, took me down face first. I landed on my hand. They cuffed me. I got up. I kneed an officer in the groin. And, I shouted some obscenities and, I was pretty mad, had a lot of
Okay, so
pain.
there was some physical resistance there.
There was.
Okay. All right. Ms. Koch, are you satisfied with the factual basis?
Yes, Your Honor.
I am, thank you.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
No, Your Honor.
And are you both satisfied that the court has complied with statute, court rule, and taken this plea?
Yes, Your Honor.
Yes, Your Honor.
All right. Mr. Witt, the court finds that your plea is knowing, voluntary, accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of both of these charges. Court will accept your guilty plea as to both. We're going to set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. You'll be here in this courtroom. Before you leave today, you're going to meet with Mr. McFalda from probation. He's going to get some information from you for a pre-sentence report. It's important that you cooperate with that process. And it's also important that you stay in touch with your attorney, Mr. Thompson, prior to that sentencing day, okay?
Yes.
Thank you, that's all.
Thank you, Your Honor. Appreciate it.
I know Mr. Vernon's here. I don't know if his client is, and I have not seen Mr. Barkley yet, so I can go to the lobby and ask for both.
Okay, perfect, thank you.
Yeah, usually over the line.
Okay, court will call people versus Dennis Woods, file number 2352201. Record should reflect Mr. Burns present here in the courtroom. Have you had any contact with Mr. Woods?
I've had lots of contact with Mr. Woods. I have absolutely no idea why he's not here. His plan was he was going to get on a Greyhound bus and be here last night, here for court this morning. And he had a Greyhound bus leaving at 9:30, so that's why we'd asked the court to reschedule him at 9. We appreciate the court doing that, but I haven't heard from Mr. Woods this morning. He's not in the lobby. I don't know what happened.
When is this your only hearing?
I have one at 10:45, I think,
Okay, so
with
let's check.
Mr. Leland.
Okay.
Judge.
What?
I noticed when I came in, there was somebody locked at the jail.
Oh.
I could contact him. Does he have a beer?
I haven't seen him in a while, so I don't know what he looks like.
I'll call real quick and see if that's him.
Oh, yeah.
See if he spent the night sitting a lot. Sometimes they do that.
Oh, okay,
And then I'll get right back with you.
okay, sounds good. So we'll check back in with the court officer. If not, then we'll touch base at 10:45.
Okay. I gotta go over to jail and talk to some clients, so
Yeah, okay,
I'll be in the building.
That's what
I'm
it
on
looked
at
like.
9:15, but I'm seeing my
No
client.
shot.
okay.
Okay.
So we'll take a recess. So we'll say 9:30. Mr. Thompson, if you see your client, just let Sarah know. Take that case, Mr. Barkley's case.
Thank you.
You said Baker was off. So they don't know.
That's what I
sentencing is within the court's discretion, we would ask the court to consider giving no upfront jail or perhaps a suspended sentence on this. Mr. Barkley is on probation out of Grand Traverse County. He's on probation with there until February. This is a substance abuse case, and this is a huge issue in Mr. Barkley's life that he's a very young man that's going to shape a lot of his future. I talked with him about his plan for remaining sober, remaining clean, and he wanted to describe that to your court, but it's something he has put time and effort into it, that he is maintaining sobriety now, and I think that's the most important thing. We're here for sentencing. Thank you.
Sir, anything you wanted to say today?
Absolutely, thank you. Your Honor, so it's taken me quite some time, honestly, to be able to admit, not to other people, but mostly myself, that I have an issue. Addiction is way more than I ever could have imagined, prior to going through it. Honestly, I know I have an issue. I'm doing everything I can. I want to go back to my words a little bit. I'm trying to do everything I can within life's, sorry, I'm nervous. I'm trying to follow the right path and do things the correct way and navigating my life throughout this course that I never imagined myself being in. It's embarrassing, to be honest with you, it really is. But it's all new to me. I'm not proud of it. I 100% take accountability for my actions. It's not like I didn't have a choice to do it or to be around it. I made those choices. They were poor choices, absolutely. But this year started off great. And it is still great. It still is going good. I'm not gonna say it's all been bad, but this year I've actually been taking sobriety seriously because I found that that's not the life for me. It's not helping me in any way, any shape, any form. I don't want to say I've lost my family, but in a sense I've drifted apart from my family, my kids, my ex. Life's tough because of my choices, and it's not what I want to continue doing. I wrote in my PSI a little bit about not believing that I was the one that put that there in my car, or that I truly didn't know it was there. After further thinking about it, and over the course of this time that I've had to think about this entire situation, I can't help but come up with the fact in my mind that I did put it there. Whether it was a week prior to or 2 weeks prior to, the fact of the matter is it was on my person. It shouldn't have been. I should have been more cautious about what's in my car, to be honest with you. Open my eyes some more, and this is what it's doing. I've been attending Munson Behavioral Outpatient weekly with Kendra Kearney, and honestly I feel like I can kind of connect with her on a more personal level going there in person, with her versus like the Zoom calls and whatnot. She's somebody that understands and listens to me and has experience in addiction. Addictions has really drifted me away in life. It's still to this day, it's not easy to admit that it's had a hold on me. It's made, it's changed me. But I'm changing myself away from them ways. I'd like to ask you to help me continue bettering myself, proving to the courts, proving to my Grand Traverse PO that that's not me, that I'm better than that. I trust that you'll make the best judgment today. Or my decisions. That's all I've got, Your Honor.
I did read through the report, so I'm familiar with why you're here on this particular charge, what happened in this case. I'm also familiar with your background and your circumstances based on the other information in the report. And I think it was a report from your Traverse City case. I got the background on that one, and so I was able to see what happened in that case as well. And I take all of that into account along with what you're saying. I agree, Ms. Koch, I think that right on that, at some point, 28, you're getting towards that end of youthful mistakes and starting to get to the point where you're either going to continue down this path for your adult life or you're going to make a change. And had some opportunities at that already. I'm not going to impose probation here. You're already on probation in Traverse City. I am going to give you an opportunity, though, to shorten your jail sentence in this case if you want to go to inpatient treatment. Because I think that would be good for you at this stage. It's not something based on what's in the report, at least that you've done up till now. And that might help you continue to deal with your substance use. Because that's obviously, I think, number one, the priority that you need to have right now. It sounds like you're taking responsibility. It sounds like you're acknowledging that you have an issue. That's an important step. Glad to hear that you're acknowledging that the methamphetamine was yours. I never, I'll say never. It's hard for me usually to believe people when they say, "Oh, I didn't know what was in there. I quit using it. I didn't know what was in there." It's been my experience that people using substances, in particular methamphetamine, never lose track of what they have and where it is. Even if they're not using, it's not something that they just, like a smoker who quit smoking finds a spare cigarette in their coat 5 years later. It doesn't happen. And I think that's important to acknowledge at this and not trying to make excuses. So I do think that there's a potential for rehabilitation here, and that's why I think it's important to give you an opportunity to pursue that if you want to. There's really no downside to the court giving you that opportunity, and there's a lot of upside for you to follow through with it. And if you don't, then you do your jail time and you move on, and you'll have to decide where you go from there. So I think the recommendation is appropriate. The jail time is right in the middle of the guidelines. I think it reflects a consideration of both the mitigating and aggravating factors here. So I think it's a good recommendation. And the court's going to follow that with the exception that I'm going to allow for you to be released to go to treatment if you decide that that's something that you want to do. So the court is going to impose 5 months in the Crawford County Jail. You have credit for 2 days served. The court will allow you to be released at any point during that sentence if you're able to obtain a bed and provide the court with written confirmation from the treatment facility that there's a bed and that they're going to accept you. I would allow you to be released to treatment for however long that program is. If you successfully complete the inpatient treatment program, then the court would give you credit for the time that you spent there and would hold any remaining time in abeyance. If you were to fail to successfully complete the treatment or be discharged from that program or leave voluntarily, then you wouldn't get credit for any of the time that you spent in treatment, and you would have to return to the jail and serve out the rest of that 5-month sentence. Or you can choose to just serve the 5 months and not go to treatment. I'm just giving you the opportunity to do that. The court is going to order a crime victim's assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. You do have the ability to seek an appeal of the sentence. I think Mr. Thompson, you've already had Mr. Barkley acknowledge receipt of the appellate rates. Is that correct?
That is correct, Your Honor. I'm just going to date those. It's today the, thank you. Mr. Barkley, you keep these.
We'd like to go in court, Mr. Barkley, or for the custody.
Second.
We had
And we have them,
Mr. Sherbet.
we have them get a
You
hold,
gave him permission.
we have them get a hold of Hannah and then.
To see him on the Zoom system.
Is here.
Okay.
Keep your head up, Russ.
I do not.
Is this your sign there?
Cyan.
I don't know.
He's in,
Is it not?
he was in Roscommon last I know. He's, violation.
Mr. Tricia, Cyan lodged in Roscommon.
Oh, sorry, I thought that was yours.
Oh,
Yep, and I did just see the Roscommon jail pop up.
Mr. Cyan, are you Daniel Cyan?
Yes, Your Honor.
Okay, go on the record in People versus Cyan. This is file number 255468. The record should reflect that Mr. Cyan's present from Roscommon County Jail by Zoom. If I could have counsel put your appearances on.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Trush on behalf of Mr. Cyan.
Thank you. Mr. Trush, can you tell me how the defense wants to proceed today on the status conference?
Well, Your Honor, I can give you a little bit of an update as to where we're at, and I can suggest to you what I think the intentions are based on that. But unfortunately, I think you'll have to directly ask Mr. Cyan that. After the last hearing, the prosecutor had made an amended offer. I went over to Roscommon's jail and spoke to Mr. Cyan about that offer. He had requested that I make a counter offer to the prosecutor. So to outline that, the offer that was tendered was pleaded delivery of a narcotic as a habitual fourth offender. That would be from the B grid to the D grid, and to plead a possession of an analog. I spoke to Mr. Cyan about that. He asked me to talk to the prosecutor about coming off the habitual fourth offender notice. I did speak to Ms. Koch about that. She is not inclined to do that. But I have not been able to talk to Mr. Cyan since that because we cannot, for the life of us, get the Prodigy system to work. We've been trying all week to get a phone call to happen unsuccessfully. I honestly have no idea what we need to do to actually make this work. But based on the conversation I did have with Mr. Cyan, I think he would be asking for a trial. But again, I would ask the court to directly.
Okay, Mr. Cyan, I can put you in a breakout room if you want to talk to Mr. Trush a little bit further, or do you know how you want to proceed?
Okay, yeah, I'd like to talk to Mr. Trush.
Okay, before we do that, Ms. Koch, I just want to confirm that the offer stands as it was originally made. Is that correct?
Well, and for the record, the offer originally was possession with intent to deliver methamphetamine. After numerous conversations with Mr. Trush, we did amend the offer to delivery less than 50 grams as a hab fourth, possession of analog. Since that time, Mr. Cyan has gotten an additional charge of making alcohol in the jail, which is a 5-year felony as a habitual fourth, which would run consecutive. I've offered to dismiss that charge if he please in this case. So that's where we stand.
Okay, so Mr. Trush, I'm going to put you into the breakout room and allow you to speak with Mr. Cyan about that. And it's just going to take me a second here to set that up. Okay, that room should be opening now. Okay, Mr. Thompson, I do have Mr. Sherbet.
Thank you.
Mr. Sherbet, if you can hear me, there we go. Okay. Sir, are you Evan Sherbet?
Yes, Your Honor.
All right, we're on the record, and this is Evan Sherbet. This is file number 255482. The record should reflect that Mr. Sherbet's appearing today by video from, I'm not sure where, but by video by prior approval of the court. And if I could have counsel put your appearances on.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of the defendant, Evan Sherbet. Your Honor, we do appreciate the accommodation to allow Mr. Sherbet to appear by Zoom. He's at the UP some distance away. There has been a plea offer made in this case. The plea offer is that if Mr. Sherbet pled guilty to count 1, possession of methamphetamine, a controlled substance, which is a 10-year felony, the prosecutor would dismiss the habitual 2 offender status and the open container and the open intoxicants.
Is that a correct statement of the plea offer, Ms. Coe?
It is.
Mr. Sherbet, did you have an opportunity to speak with Mr. Thompson about this plea agreement?
Yes, I did.
Did you want to move forward with that agreement today?
I'm not really sure. I'd like to speak to him one more time about it, and then I would have my my final on it. But I assume probably yes.
All right, Mr. Thompson, do you have a device that you can sign in? Do you want to talk to Mr. Sherbet here while we're on the record today?
Certainly.
So, Mr. Sherbet, I'm going to create a breakout room here on Zoom so that you can have a conversation with Mr. Thompson.
Okay.
And so we'll either move forward with that plea agreement today or we'll set it for trial, okay?
Okay, thank you.
So it's just going to take a second to set that breakout room up here. How to create another room here. Just a second. You know how to create a second breakout?
I do that.
I've never really
know how to sign it.
I mean,
Do you want?
I would probably just wait for the first meeting then.
I know there's a way to do it.
That's as advanced as I am.
I'm surprised it's not. I haven't had to do it yet.
Are you here this afternoon?
Yes, I live here.
I might ask to move the arraignment on the felony murder case.
Just unsorted.
Yeah, so someone else could talk to her.
Okay. That makes the most sense.
Ravi's on vacation. Richardson at Seagull. And James Dick is unavailable.
Might be able to get Adam to come talk to her. He's back at 10:45.
Yeah, do you want me to just call Mr. Sherbet?
Yeah.
Okay, yeah, we'll go do that.
That might be
So,
quicker.
Mr. Sherbet, Mr. Thompson's just gonna call you directly, so if you need to disconnect from this meeting and then reconnect after you talk to him, you can do that.
Okay, yeah, that sounds good. I'll just mute it and drop the video, and I'll have him on the phone.
Okay, thank you.
Yep.
Thanks, good suggestion.
I don't know if it's been working, but
It looks
Go
like you
old
got-
school. Old school.
yeah, I'm like, well, yes, or we can actually do that for that right now.
For essentially a plea cutoff. I spoke to Ms. Doak. The defendant was trying to get into sobriety court. She did the assessment the day before our last hearing. Ms. Doak got the assessment back and it indicated she was not eligible for sobriety court, but could possibly change if she was able to get additional information. Ms. Doak herself had a death in her immediate family and has had some issues that have kept her out of the office for a few weeks. Typically, I would at this point say we need to move forward, and frankly, we do. This case is, we're getting close to 9 months, but given Ms. Doak's situation, I would ask for a 2-week adjournment. That after that, the plea will be pulled and we're not going to continue this. We'll either go to trial or she can enter a plea to the OWVI third at that time. That's where we're standing.
Ms. Doak?
I appreciate her putting on the record. Thank you. I agree. That was the nature of the conversation. And that is actually what.
Is that how you want to proceed?
Yeah, I mean, I would appreciate more than 2 weeks, but it's obviously up to the prosecutor, which she basically offered.
Ms. Sunday, do you have any objections to the adjournment? We'll put this on for December 4th. Set it as a police status conference. So this Sunday, you'll need to be prepared that day with the final decision as to whether you want to enter into a plea or proceed to trial, okay?
Yes, sir. And Your Honor, what time would there be in the morning again?
I don't know. It'll be in the morning. I just don't know.
In the morning?
Yeah.
Yeah, okay, great. Yeah, I have something in the afternoon, but morning would be great.
Okay.
Thank you, Your Honor.
All right, so Ms. Sunday, between now and then, just make sure you stay in touch with Ms. Doak. The court will send both notices of the date.
Thank you.
Thank you.
Thank you. Okay, Mr. Trush, are you ready to continue?
We are, Your Honor, just waiting for Mr. Cyan to pop back in.
Okay. It's going to be 50 seconds. Oh, maybe not. Okay, here we go. All right, Mr. Cyan, are you able to hear me? You need to unmute on your end. Okay, we have Mr. Cyan back. Mr. Trush, how did we want to proceed today?
Your Honor, we would ask the court to docket the matter for a trial. I'd ask the court to set a final status conference at the motion date prior to the trial.
Just looking at the one-day jury trial.
Yes.
Mr. Trush, is one day enough to try this case?
I would agree with that assessment.
Okay. And Ms. Koch, if the court sets this 60 to 90 days out, is that enough time for you to be ready?
That is fine. I would ask for the final status conference to be in 30 days so we can pull the plea offer and get his other case, his other felony case started so we can catch them up.
Okay. Mr. Trush, any objection to that 60 to 90 day time frame for the trial date?
No, that's fine.
Okay. And given that this plea offer involves the potential dismissal of these additional charges, I think it's reasonable to set that plea cutoff for 30 days as opposed to immediately before trial. So we'll set this for a final status conference in about 30 days. That'll be the plea cutoff. So Mr. Cyan, to the extent that you did want to consider any plea offers, that conference would be the last date to enter into any pleas, okay?
All right, thank you, Your Honor.
Okay, Mr. Trush, is there anything else I can address for your side here today?
No, Your Honor, thank you.
Ms. Koch?
No.
All right, Mr. Cyan, do you have any questions about how we're going to proceed with your case?
Not that I can think of at this moment.
Okay, thank you. That's all for today, and all parties are free to disconnect on this file.
Thank you, Your Honor.
Okay, Mr. Thompson, are you ready on Mr. Sherwood's case?
I am. Does he sign back in?
Yeah, Mr.
Okay.
Sherwood, if you can unmute again, please. Okay. All right, Mr. Sherwood, did you have an adequate opportunity to speak with Mr. Thompson?
Yes, Your Honor.
Okay, did you want to proceed with that agreement today?
Yes.
And again, that's, I forgot what it was. Plead
Yes,
count one.
plead guilty
with no
to count one, dismiss the enhancement and dismiss count two, which is the misdemeanor open intoxicants. So be pleading count one, possession of methamphetamine and 10-year felony.
Okay, that's correct, Ms. Koch.
Yes.
Okay, Mr. Sherwood, if you can raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, Your Honor.
Thank you. You can lower your hand. Mr. Sherwood, are you currently on any kind of probation or parole?
No.
And as Mr. Thompson said, the maximum possible penalty for this charge of possession of methamphetamine is up to 10 years and or a $15,000 fine. Do you understand that?
Yes, Your Honor.
All right. With that in mind, what is your plea to that charge today?
Guilty.
Right now, you have certain rights. I'm going to go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf to appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it. You understand all of those rights?
Yes, I do.
You understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, I do.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that?
Yes, I do.
Has anyone threatened you with anything to get you to plead guilty?
No,
Has anyone promised you anything other than what we said here today on the record in court?
no,
Is it your own free choice to enter this plea?
yes,
Are you pleading guilty because you are actually guilty of this charge?
yes,
The information I have indicates this happened on July 27th of 2025. Is that the correct time frame?
yes,
On that date, were you here in Crawford County?
yes,
And when you were here in Crawford County, did you have possession of some methamphetamine?
yes,
Did you know that that's what that substance was?
yes,
Did you have any legal right to have any amount of it at that time?
no,
Ms. Koch, are the people satisfied with the factual basis?
Yes.
Mr. Thompson?
Yes.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
No, Your Honor.
Are you both satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Yes, Your Honor.
Mr. Sherbet, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. It'll be in about 30 days. That hearing will be in person here in the courthouse at Crawford County, so you'll need to make arrangements to travel here to Grayling for purposes of that hearing. In the meantime, somebody from the probation department will be in touch with you to do a pre-sentence report. And it's important that you follow up with that. When you get that contact, Mr. Thompson, can you provide that contact information, Mr. Elba?
I can, Your Honor. I did want to address the sentencing date.
Okay.
When I was looking at the court docket, it looked likely it was going to be that first Thursday in December. And Mr. Sherbet advises me he's got an appointment around that. I can't remember it's the day of, but if it's for, he's got advanced cirrhosis of his liver. He has a liver specialist that he sees. That'd be difficult to do a different appointment, and it's not something the jail can, replicate at our local ER. So could we have a January sentencing date, please?
Ms. Koch?
I don't have any objection.
Okay, yeah, I don't have an objection to that. I think their December docket is rather full, so we'll set it for January sentencing.
And
I don't have a January, can't read it.
Okay, so we'll set it. Half day in December is 15th.
Yes.
I thought you weren't available on your half day in December. I got a message to that effect last week or so.
Judge Hunter is not available on 11/17.
I'm gonna set it for January. I know that I have a full day available in January, so. So we'll set it for January. So Mr. Sherbet, again, somebody from the probation department is going to be in touch with you using the phone number that Mr. Thompson's going to give them. And so make sure that you follow up with that contact, okay?
Okay, sounds good. Thank you, Your Honor.
Yeah, I mean, just following up on that, I had a message from Jen saying no Judge Mertz docket on 12/15/25. Maybe that's a jury trial that's since come off, but that's why I said that.
I can't remember sitting here. Either way,
Sure.
it's not an issue. So
Okay, thank you, Your Honor.
I'll try not to set it.
Yeah.
Thank you, Your Honor.
It's not my fault.
Okay, you're free to disconnect.
He knows he has to meet with you in person. He comes through sometimes. So within 2 weeks, he'll be coming through if that's okay.
Okay, People versus Kirk Pritchard, file number 255460.
Sierra
Your Honor,
Coke.
Troy Daniel, appearing Mr. Pritchard. This is the brief status conference. It's my understanding to be a plea.
Okay.
If I may approach, I do have an advice rights form that was signed today by Mr. Pritchard.
Thank you. All right, and Mr. Daniel, can you tell me the terms of the plea agreement?
Yes, Your Honor, it's my understanding that Mr. Pritchard is going to plea to operate when visibly impaired as a third offense, and that the habitual fourth notice would be dismissed.
That's a correct statement of the offer, Your Honor.
Okay. Mr. Pritchard, have you had an adequate opportunity to speak with Mr. Daniel about this agreement?
Yes, I have.
And is that how you want to go forward today?
Yes, I do.
Can you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Remove your hand. Mr. Pritchard, are you currently on any kind of probation or parole?
I am not.
And you understand that by pleading guilty to operating while intoxicated as a third offense, that the maximum possible penalty you could face would be up to 5 years and or a $5,000 fine?
Yes, I do.
With that in mind, what is your plea to that charge today?
I plead guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights?
Yes, I do.
You understand that you're giving up and waiving all of those rights by pleading guilty?
Yes.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only do that by leave. That means that you would have to ask for the Court of Appeals to hear your case. If they said no, then that would be the end of your appeal. Do you understand that?
Yes.
Has anybody threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we said here today in the courtroom?
No.
Is it your own free choice to enter this plea?
Yes, it is.
Are you pleading guilty because you are in fact guilty of this charge?
Yes, I am.
The information I have indicates that this took place back in 2025. Is that the correct day?
Correct.
On that day, had you been consuming alcohol?
Yes, I was.
And after you consumed alcohol, did you operate a vehicle on Wilcox Bridge Road here in Crawford County?
Yes, I did.
And did you have any blood or breath tests to determine the level of alcohol in your system?
Yes, I did. I had a blood test at the hospital.
And do you know what the result of that test was?
0.185.
Okay. Do you have any reason to doubt the accuracy of that test?
No, I do not.
Had you consumed enough alcohol that day before driving that you believe that you were intoxicated while you were driving?
Yes, I did.
Had you previously been convicted of operating while intoxicated back in 1999 here in Crawford County?
Yes, I have.
And then also in 2006?
Correct.
Right. Mr. Koch, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Dan?
Yes, Your Honor.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
No, Your Honor.
Are you both satisfied that the court has complied with statute and court rule in taking of this?
Yes, Your Honor.
Yes, I am, Your Honor.
Mr. Pritchard, the court finds that your plea is knowing, voluntary, accurate. The court is satisfied that there is a factual basis to support the fact that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing along with Mr. Daniel. It's important that you stay in touch with him prior to that date. Also, before you leave court today, you're going to meet with Mr. McFelda from the probation department. He's going to set up a time for you for a pre-sentence report, okay?
Okay, thank you, Your Honor.
Thank you.
Thank you, Your Honor. I don't, you, I mean, I don't know.
I think it's 6253.
I might be interested in seeing it.
I can't find it.
People versus Dale Wakely, file number 255479.
Sierra Coke on behalf of the people.
Your Honor, good morning. Nicholas Robinson on behalf of, excuse me, Mr. Wakely, could you go to the podium right now?
The case or the plea? I mean, he has an offer.
I think it was pleading.
First delivery distance left, which was.
He has one? Really? Okay.
Let's start with, I see a toxicologist.
Erica Walker, and we have Alicia Norgon here for the hearing. I'm not sure if they still want to run the hearing, but we are prepared to go forward.
Counsel, I mean, we're here for a status conference and hearing on the bond violation. So,
Your Honor, as far as this goes and as far as public testing, you know, I believe that his bond has already been revoked and he has reposted bond on this. As far as hearing, we can go forward with that, Your Honor.
okay, so you're testing whether or not Mr. Wakely violated his bond.
We would do that.
Oh, so Ms. Coke, who would you like to call first?
Alicia Norgon.
Ask them to come forward. Ms. Medler will swear you in and then.
Please raise your hand and you tell me swear or affirm that the testimony about to give today should be the truth, the whole truth, and nothing but the truth. Yeah.
Let's say your first and last name, spell both for the record, please.
Alicia Norgon, Norhagon.
Ms. Norgon, where are you currently employed? Okay, and how long have you been employed there? As part of your employment, do you do any drug testing?
I do.
Can you tell me what your training is to do that?
Taken several training courses through the court, certified for oral testing and several different companies, urine testing.
On 9/5/25, did you test Dale Wakely?
I did.
Okay, do you see Dale Wakely in the courtroom today? Can you tell me what he's wearing?
Black police.
Your Honor, I asked that the record reflect that she'd identified the defendant as the person she tested on 9/5/25.
Okay, thank you.
Okay, on that day, what did you do?
I administered this drug test.
Okay, and what type of test did you do? Okay, and that's one of the ones you're certified on? And what was the results of those tests?
It's positive for methamphetamine.
I'm going to show you what's been marked as People's Exhibit 1. Is this a document that you filled out that day? People moved to enter People's Exhibit 1.
No objection.
Or will admit this exhibit.
The test that you used in that case, is that one that this court has chosen for you to use?
Yes.
Okay. Once you do that test, what do you do next?
I sent it into the lab for confirmation.
So they do a second confirmation on that test? How do you package up the test when you're done?
There is I make sure I have a fresh pair of gloves on. There's a security seal listed over the container, seal it, initial it, date it. Forms saying I believe that it's positive for, it's put in a secure envelope, sealed properly. There's no way you can tamper with it. It's sealed. And then get a FedEx overnight pickup, send it that.
And what is the lab that you send it to?
Redwood toxology.
Okay. I have no further questions for Ms. Norgon.
Thank you, Mr. Robinson.
Thank you. And just briefly, as far as this test goes, this is a swab that you used, is that correct? And this is something that was properly sealed when you opened it, is that correct? And as far as these swabs go, has there ever been a situation where you've had any false positives in your experience?
Not that I can recall.
Not that you can recall? Okay. And as far as anything in your department, is there anything, maybe not you or, but anybody else in your department has had any problem with false positives in the past? Not that you're aware of. Okay. And as far as the labeling on this, are you the one that did the packaging on this? And you were the one that did the labeling, is that correct? And were you the one that took it to FedEx and dropped it off at FedEx?
I secure it in the FedEx envelope, put it in the, they come pick it up from office with the,
Okay, and the labels and all that, that's something that's done by you or that's something that's done by somebody?
no, it's all done by me.
All done by you, okay. Your Honor, I have no further questions on that.
Any follow-up questions?
Not for Ms. Norgon.
Thank you. Did you want me to bring in the tax account?
Yes. Yes, thank you.
Okay, Ms. Walker, are you able to hear me okay?
Yes, Your Honor. Thank you.
All right, thank you. You're being called as a witness today in the matter of the People versus Dale Wakely. And I'm going to swear you in, and then we're going to take your testimony. If at any point you can't hear what's being said, please let us know and I can have that repeated for you. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
Thank you. You can lower your hand. And Ms. Walker, if you would state your first and last name for the record and spell both.
It's Erica Walker, ERIKA WALKER.
Thank you. Ms. Coach, proceed when you're ready.
Ms. Walker, where are you employed?
I'm employed at Redwood Toxicology Laboratory, which is known as Abbott in Santa Rosa, California.
And what is your title there?
I'm a forensic toxicologist.
How long have you been a forensic toxicologist?
Actually, I've been since 1995.
Do you have any idea how many drug tests you've done in that capacity?
I would say thousands.
Okay. Is the Redwood Toxicology Laboratory certified to accept human specimens for the purpose of performing laboratory examinations?
Yes, ma'am.
Are you registered? Is the Redwood Toxicology Lab registered with the Drug Enforcement Agency to perform chemical analysis of controlled substances schedules 1 through 4?
Yes, ma'am.
What do you do in your duty as a forensic toxicologist with Redwood?
What I do, I review and interpret drug results for various agencies throughout the United States. I am also the custodian of those results. I testify to those results. I provide letters of interpretation, litigation packets, participate in peer review and ongoing studies, just to name a few. Also to testing, also provide testing.
Have you been found as an expert as a forensic toxicology in courts before?
Yes, in federal, state, and local courts.
Do you know how many times?
Well over 500 times.
Your Honor, I would ask that she be found as an expert as a forensic toxicologist.
No objection.
All right, the court will recognize Ms. Walker as an expert in that field and she may give any testimony.
Ms. Walker, did you review the results for Dale Wakely that were given to Redwood Toxicology?
Yes, ma'am.
How did those results come to you?
It comes in either through UPS or FedEx. An accessioning technician will review the specimen and make sure that it's intact, review the specimen along with a requisition form, and make sure all information on that form matches the specimen. Make sure it's intact. If it wasn't, then we'll notify the client right away to let them know that something's wrong with the specimen, to see if they can give us a new specimen, or if they want us to still move forward if there's specimen left. But if everything's fine, it was logged into our laboratory management system, then it moves forward for testing.
Was this specimen intact when it was received by Redwood Toxicology?
Yes, ma'am. If it wasn't, then it'll be notated. If you look at the report under the comments section, it would be notated there.
Okay. So if there's nothing in the comment section, it was intact?
Yes, ma'am.
Did you perform any additional analysis on this specimen yourself?
Myself, no, I consider the custodian of records, so I review the specimen and the processes and the testing all along the way before it was sent out to the client.
Your Honor, at this time, I'd like to object to all of this testimony. If she was not supervising the actual test and she did not perform the actual test, I don't believe that this should come in. I think this would be hearsay at this point. So,
Your Honor, this is a business record that's kept in the regular business. This is the lab that does it, and she is the custodian of that record.
and that may be fine, but what we need here, Your Honor, is somebody to testify about actually doing this test or supervising this test. Outside of that, I don't believe that this should be admitted.
All right, so I will admit the testimony for the purpose that she's testifying as a records custodian. I'll admit her testimony for the purposes of showing that their records reflect that this test was done, that it was received, what the result was. I will not take that testimony for the accuracy or the dependability of those results.
Thank you.
Sustaining your objection and limiting why the court would accept the testimony.
Ms. Walker, who did the actual test within your agency, if you know?
I don't have it right offhand, but I did see who did provided the testing. That could be provided to the courts if requested. We can do a litigation packet.
Okay. Do you oversee the testing yourself, or do you just get the records?
I get the records, and sometimes I do oversee it because I do participate in testing from time to time.
Okay. In this case, did you oversee this specific test?
No, I did not.
The record shows that Abbott did a confirmation test. Have you reviewed that?
Yes, ma'am.
Is that the accurate record that is kept by Redwood Toxicology?
Yes, it is.
People move to enter People's Exhibit 2.
Your Honor, at this time, again, we would object to this being entered, Your Honor. This is a situation where we're not able to cross-examine, we're not able to test the reliability and accuracy of these actual test results. I don't think that this should come in at this time.
So I'll accept the exhibit as a business record. Again, I won't take it as evidence that the test was accurate. I will take it as evidence that that's the records that they have reflecting the outcome of the test.
Thank you. I have no further questions for Ms. Walker.
Your Honor, concerning this witness, we do not have any questions for her.
All right, thank you. Ms. Walker, we're going to disconnect now. Thank you for your time today.
Thank you, Your Honor. Thank you, everyone.
Okay, Ms. Koch, anything further from your side?
No.
Robinson.
No, Your Honor.
Ms. Koch, argument.
Your Honor, in this case, the bond violation was the use of methamphetamine. Ms. Norgon testified that she is certified by this court by district courts to do these tests. She did the test herself. She identified that she tested Mr. Wakely and that it tested positive. As part of her procedure, she actually sends it out for additional and confirmation testing, just to make sure there are no issues. As defense counsel asked, are there false positives? She said no, but she did send the testing out for additional confirmation by Redwood Toxicology. That business record has been submitted. There's no evidence that there's been any issues at all with the sample or that it was a false positive in any way. Mr. Wakely tested positive for methamphetamine. Thank you.
Your Honor, again, we object to all of this. This is a situation where Mr. Wakely has a constitutional right to be able to confront and to test all of the witnesses and all the evidence that's against him. What we have here, Your Honor, is a test that this court has received that does show it's positive, but we haven't had the opportunity to test these results to be able to cross-examine as far as the accuracy of these results and the reliability of all this, Your Honor. So for all of that, Your Honor, we object to all of this, and we would ask this court to take that into consideration when the court does make its ruling.
All right, thank you. First of all, the court has to acknowledge the nature of the proceeding here, which is this is not a trial. I'm not determining whether or not beyond a reasonable doubt Mr. Wakely was using methamphetamine while he was on bond. This is a bond hearing. It's a low standard. The court just has to find reasonable cause to believe that Mr. Wakely did violate his bond by using methamphetamine. I'm satisfied based on the evidence presented today and the lack of really any kind of other explanation for Mr. Wakely testing positive, that it's much more likely than not that he was using methamphetamine while on bond. So the court will find that Mr. Wakely has violated his bond. Now, the question as to what to do about that, Mr. Wakely was provided with an initial bond of $30,000 cash or surety on May 21st. And I guess this is where counsel can correct me in terms of procedurally where we're at, but that it appears that this violation occurred in September, right? According to People's Exhibit 1, tested positive on September 5th. And then subsequent to that, there was a petition and bench warrant for failure to comply with bond that was signed by Judge Burmeister on September 11th. And an order was entered to revoke his bond on September 11th by Judge Burmeister. Then it appears to me that, based on our records, then a new bond was issued on September 17th. In the amount of $50,000 cash assured, which was posted by Mr. Wakely. And so it looks to me like Judge Burmeister already considered this bond violation and then issued a new higher bond as a result of it. So my question is, Ms. Coe, what are you asking the court to change Judge Burmeister's new bond decision based on this violation?
Well, procedurally, when we got to that hearing, at least my notes say that they wanted a hearing, they were contesting the bond violation, and so the judge set a new bond. So there was no sentencing on the bond violation, you just got a new bond. I will say that each of the courts in this county do bond violations very differently and handle them very differently. But at least the way I see it procedurally is he was never sentenced on the bond violation. Because he just said he wanted a hearing and got a new bond. How the court wants to proceed, as I said, all of our judges here do this extremely different, and I would defer to the court as how the court wants to handle it.
All right, so the way I've never imposed, a contempt sanction or something like that based on a bond violation. I don't know, frankly, I don't know that I have authority to do that. I don't know whether other judges do that or not. Considering the bond violation in this case, I think Judge Burmeister's decision to raise the bond by $20,000 in light of what he considered to be a violation at that time to be an adequate way to address the violation. I think to the extent that there are additional violations, the court may have a different opinion about the proper way to proceed. But as it is, I think, again, that was an appropriate decision by Judge Burmeister. I'm not to alter that or impose anything different. So the court will acknowledge that we've had a full hearing at this point, I believe, and I've made a finding as a matter of record that there was a violation. So that puts Mr. Wakely in a position to be subject to more harsher actions for further violations. That, along with raising the bond, which Judge Burmeister did, is, in my view, an adequate way to proceed. So I'll have bond continue at the $50,000 as set by Judge Burmeister on September 17th. And in terms of the status conference today, Mr. Robinson, tell me, have there been plea discussions? Are we going to have a resolution, or should the court docket this for trial?
Your Honor, I think at this point, if this court could consider documents for trial, we do hold out hope, Your Honor, of a resolution at this, on this matter, but at this time, I don't think we're quite there.
Ms. Koch, 60 to 90 days adequate period of time to be ready to go to trial.
Yes, the plea offer was made 5 months ago.
Mr. Robinson, is that enough time for you?
Your Honor, that's more than enough time. What I would ask the court to consider as far as the trial date, if the court has any availability in February, that would probably be the next time that I would be available for trial, if that's possible.
I think that's probably a realistic timeframe based on my trial schedule.
Yes, not sure what you have going on here.
And Ms. Koch, is 1 day could be enough?
Yes.
Mr. Robinson?
I believe so.
So we'll set this for a 1 day trial. I'm assuming by jury, Mr. Robinson?
Yes, please.
By jury in February 2026. Or we'll set this for the final status conference. It's full motion day prior to the trial date, so Mr. Robinson, you and your client will get notice of that date. That'll be the plea cutoff, so Mr. Wakely, to the extent that you want to consider any plea offers, that final status conference prior to your trial would be the last date to enter into pleas. For counsel, that would also be the motion cutoff, so to the extent that there are any motions, they would need to be filed and heard no later than the date of that final status conference. And Mr. Robinson, along with notices for the hearings on those dates, you'll also get a pretrial order reflecting the cutoffs and so forth.
Very good. And all of those notices will come from your office by mail, is that correct? Thank you.
And anything else to address today for yours?
No, we will get our notices out shortly.
Mr. Robinson?
Nothing further, Judge. Thank you.
Thank you. That's all for today. Versus Brian, case number 235211.
Sierra Coke on behalf of the people.
Reflect that Mr. Schlapp is present here in the courtroom. Mr. Schlapp, are you represented by counsel?
No, Your Honor.
Mr. Schlapp, you understand that you do have the right to have an attorney present. That you can't afford an attorney, one would be appointed for you at public expense.
Yes, sir.
And is it your desire to represent yourself today?
Yes, sir.
Okay. You understand that there are, and this is a sentencing hearing on a probation violation. You understand that there are matters of procedure and substance of the law that a lawyer might be able to advise you on, would be able to go through that pre-sentence report with you, make sure that you understood all the consequences and implications of that. You understand that?
Yes.
And that without that advice from an attorney, that could potentially put you at a disadvantage where you might not be aware of some arguments that could be made on your behalf or the consequences of your actions today.
I'm ready to go forward.
You're willing to take those risks and still represent yourself.
Yes, sir.
Have you had a chance to look at that pre-sentence report?
Yes, sir.
Okay. Is there anything in there, just in terms of the factual information, that you feel is inaccurate or incorrect?
No, Your Honor.
Ms. Koch, do you have any corrections or additions or deletions?
No.
Anything on behalf of?
I understand the recommendation from the probation department. We have somebody who here is on bond for, on probation for operating while intoxicated, third offense. He was given the opportunity by this court to go to inpatient treatment in lieu of some jail, which he completed in January of 2024. And now we're running into him using alcohol to a level so excessive that he can't even be taken into the jail without a medical clearance. On one check, he was a 0.295. On another check, he was 0.15. These are very dangerous levels. I don't know why Mr. Schlaff, frankly, isn't taking this more seriously, especially given that he's already done rehab. I understand the request to continue him on probation, to monitor him. I frankly don't know how successful that is going to be with somebody who's already done rehab and is at levels of close to 0.3. I don't really know what this court can do to get it through to Mr. Schlaff that he should not be drinking, but I defer to the court. Thank you.
Mr. McDowell, is there anything that you wanted to add to that?
I understand what the prosecutor's saying. That after filing these charges, I will say Mr. Schlaff has got himself sober. He started with some medications that helped him with his drinking. He's from what I've seen and tested and believed just by physical appearance, I believe he is remaining sober since that time. And I talked to his family members. So this recommendation is a little bit strange, but I've been just asking for a couple month extension just to continue monitoring how he's doing, because for the first time since I've had him on probation, I truly believe he's actually staying sober. And I know it's maybe a short time, in the grand scheme of things, but I do think he's on the right path. I would just like a couple months to continue monitoring. And I've talked to Brian about that, and I think we're all in agreement on that.
All right. Thank you, Mr. Schlaff.
Mr. Honor, the morning that I got out the last time that I got arrested for, I went straight to my doctor. I asked my doctor for help, and he said he would help me get through this and put me on some medication. Causes, if I drink, it blocks it, I guess, somehow, and I can't feel the effects. I haven't had a drink since that day. The first time in my life, my wife is telling me she's proud of me. Just realized I'm just ready to be a different man. I just can't live in that life. Just in the past 90 days, I feel like a different person. The way people look at me. I'm just really proud of myself and plan on keeping this going. No, I failed in the past. But I've got so many people supporting me that I just don't want to let them down.
All right, well, I read through the report. I was concerned about the violations for the same reasons that Ms. Koch indicated. And I think certainly an argument to be made that some jail time should be imposed at this time. I also have been working with Mr. McFalda long enough to know that he's not somebody who sugarcoats things. And so the fact that he's making this recommendation says something to me about progress and where you're at right now. So I think if he felt you were a danger, there was a problem here, he would have no qualms about recommending jail time up to the full amount. So I'm going to follow that recommendation and extend the probation as indicated. I do want to caution you though that to the extent that there are any violations, I think we're going to be back here with much different result. Likely a lot of jail time. I've got up to 11 months in the guidelines here. So I hope to stay on the right path. It sounds like you're on that path right now. Glad that you're getting some medical help. That can make a huge difference for somebody who's been using alcohol for as long as you have, to the extent. I really think you need that, so I hope you can do that as well. So, does he need to check in with you?
I'm gonna talk to him briefly here.
And Mr. So, yeah, can somebody look and see if we have a note, right? So, last time I sent it. There is. I don't know where it is.
Give me the pen. Here you go.
Sir, can you help?
Thank you. It's right in the middle of the page.
That's okay. So this is just enough that you need the date, which is 11/6, and then right here, this is if you are wanting to appeal what just happened. So just cross it out, initial that. And then date and initial. Stop copy.
All right, we ready on Mr. Wilson's case?
Yes, thank you.
Okay, People versus Joel Wilson. And this is file number 255421. Counsel for the petition.
Anthony Juliet on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of the defendant Joel Wilson. Were there two files up today, Your Honor?
There are. The other one is 245280. So, Mr. Thompson.
Thank you. Mr. Wilson suffers from a hernia. Could he be allowed to sit today? Thank you. In terms of this, Your Honor, first of all, Mr. Seeger's counsel of record on the older file. He asked me if I could cover this today. I said I could.
Okay.
Mr. Wilson sent it to that. My file, this is a first hearing. We are, I would say, very close to a plea agreement. I think this might require a little discussion with the court, but we're close to a plea agreement, but it's not quite finalized. For my file, I'd be asking for 30 days, and I think that's appropriate with the timelines. I don't know if Mr. Seeger's case is of an age where the court would feel the need to set a trial date, but if so, I would ask that we have a final scheduling conference and that the plea cutoff be extended. Again, I will represent the court that we're very close to resolving both cases with a global offer.
All right, counsel.
That's correct. If we could just set the newer file out approximately 30 days, I would have no objection to that. If the court feels the older file should be set for a final status conference with a plea cutoff on the same date, I think that would be most efficient.
So Mr. Seeger's file has an offense date of January 25. Mr. Seeger file has an offense date of June 24. I don't really know which is the older one. It sounds like
Sorry, mine is procedurally much younger. This is our first time in front of Your Honor.
Okay, gotcha.
So that's what I meant when I referred to Mr. Seeger's file, the R&O file. I would understand if the court needed to set a trial, but I would ask for final status conference and a plea cutoff in approximately 30 days. On my file, I'm asking for 30 days. That's appropriate given it's my first hearing.
All right, so I'd like to see if we could just get this all resolved at one hearing. So I'm gonna set both of them for a plea hearing status conference in 30 days. As to Mr. Seeger's file, I will make that the plea cutoff. That was found over in May. So I mean, that something needs to happen on that file. Yes, a final decision. So, Mr. Wilson, that's your resisting and obstructing cases. That's one of Mr. Seeger's your attorney.
Yes, Your Honor.
So on that case, you need to have a final decision about any plea agreements that are next year in about a month. Okay.
Yes, Your Honor.
You have any questions about that?
No, Your Honor.
All right. And then if we can reach some kind of global resolution, then let's do that at the next hearing.
We will, Your Honor. Thank you.
Very good.
Thank you.
Thanks for coming down.
Vernon, were you ready on Mr. Leland's case?
Yes.
People versus Eric Leland, file number 245.
Sierra Coke on behalf of the people.
And we're on behalf of Mr. Leland.
Record should reflect that Mr. Leland's present here in the court today. I'm gonna have you come right to the podium there, sir.
Your Honor, I did have a meeting with Mr. Leland this morning. He advised me he was not happy with my representation and would ask the court to appoint new counsel. There has been a breakdown in communication. And to be fair, Mr. Leland had asked me to take a few steps and talk to a few people, and I have not yet accomplished that. I think that's the basis of his frustration and request for new counsel.
Let me just get a sense. This case was found over quite a while ago. Oh, I see. Okay. Leland, it was like we had this kind of for a period of time.
Yeah. Okay. Lost my home. So, all right, I just kind of moved next door. That's it.
Okay, so tell me, when were you appointed on this case?
It would have been back over. It would have, yeah, it would spend, I mean, at least 6 or 8 months. It was beginning of summer, right?
He was arrested on the warrant in October.
Oh, I apologize. I'm thinking of something different then.
I think he must be because I think he.
I can check and see what time.
I have to think that you were disappointed about it less than a month ago, like 3 weeks ago.
14th of October.
So we sent out our engagement letter on April 9th.
On 25.
Yes.
I think we did,
I think that was just part of Mr. Germer's cases.
yes, I think there was a bunch of them sent to their office, but there was a bench warrant for Mr. Leland that was outstanding. So until he got picked up, I think is.
There was an appearance for Mr. Jaskowski, the other Mr. Jaskowski on 1/17/24. And then Robbie was originally on his case, and then Vernon came out, but I do not see.
Mr. Vernon filed an appearance on 4/8/25.
Yeah, so I think what happened, Mr. Vernon, is when Mr. Germer came off the contract, this was a case that you were assigned to, Mr.
Oh, we didn't take any steps on it until recently.
Still,
and I think that's
his
correct.
whereabouts were unknown until about 3 weeks ago.
And I think my answer is still an accurate one when I appointed on this matter. So I think.
That's true, the technical point, but you haven't had any interaction.
Yes.
So Mr. Leland, what's gone on in the last 3 weeks that makes you think that Mr. Vernon isn't represented adequately?
May I speak freely? Okay, so there's 3 things I asked him. I signed over full disclosure for my daughter to know what's going on. Unfortunately, I have onset Alzheimer's and dementia is kind of kicking in right now to a certain extent. So she goes over it with me, you know what I mean, just so I fully understand the outcome of what's going to happen. And she's called him multiple times and no response on his end. I asked him to speak with my wife over concerning the matter, and but she's also incarcerated here at this moment, and he didn't do that either. So I mean, all I'm asking for was fair representation. You know, I'm not asking to get away with anything. I just want to be, you know, I had the time to. I just feel like he doesn't have the time to, you know, he was always busy. You know, I mean, he just didn't, no communication. I mean, I said, you know, that's basically all it is. You know, I just wanted a fair trial. You know, I'm not asking to get away with anything. Okay, I'm just asking for, you know, fair representation. And I don't feel like it's just been quite inadequate.
And And Your Honor, I would like to add, there is a co-defendant. It is Kimberly Leland. It is his wife. She does have her own attorney. She entered a plea on 10/20/25 here in this court with a different counsel. So Mr. Vernon probably can't speak to her, but she pled to possession of methamphetamine with a 7411 on her case. She hasn't been sentenced yet. She testified in her plea that the 300 grams of methamphetamine found in the vehicle were Mr. Leland's. She is scheduled for sentencing on 11/17/2025 in front of Your Honor.
So, if I may, so I did speak to Jason Thompson, who is the wife's attorney, and I do have permission to go speak with her. I got that permission this morning. And to be fair, the witness at her plea identified that she didn't know that there was 300 grams. That there was, she thought it was 3 grams. So there was that's a statement that is certainly subject to, review. But I think those are things he wants me to talk to her about. So again, I'm not suggesting that he's, that I have done the things he has asked me to do. I'm simply identifying that he's made those requests are not unreasonable. I have not yet gotten to them. He's annoyed by that.
All right. So Mr. Leland, number one, we have a process here in Michigan now where if somebody requests court appointed counsel, I refer that to our local indigent defense counsel administrator, who is Mr. Thompson. So the next step, I can't reappoint new counsel for you today. Go to him. He would determine whether or not if your complaints are valid and would justify having new counsel appointed. If he finds that they do, then he'll appoint a different attorney for you. If he finds that they don't, then you can appeal that, and then I would make a decision. I can tell you, in the scheme of things, Mr. Vernon is really just getting started in terms of his representation. 3 weeks isn't a lot of time. Be really difficult for me to find that 3 weeks is enough time to justify appointing a new counsel, but Mr. Thompson may have a different view of that. The other thing is that process is going to result in a delay of your case. So I'm certainly willing to do that. You have the right to request a different counsel, and I'll refer that to Mr. Thompson to follow that process. Is that what you would like to do? Yes, sir. Okay. So I will set this for another status conference in 2 weeks. That's my next available date. Between now and then, Mr. Vernon, I would just request you communicate with Mr. Thompson about Mr. Leland's request, and have Mr. Thompson make a decision on that and notify the court prior to that next hearing.
So I understand that I should not take any additional steps that Mr. Leland has asked me to do with regard to talking to him.
No, you should. You're still counsel of record, and you will be until such time as you're substituted out.
Thank you for clarifying.
Yeah, so please continue to provide all representation.
Okay.
And then Mr. Leland will proceed in 2 weeks with your case. Okay. Thank you. Do you have any questions about that at all? All right, thank you. That's all.
And I would say that as we sit here thinking about it, Mr. Thompson represented the wife, so he probably can't represent.
Yeah, he would have to certainly.
Probably have to go outside the contract for that.
Yeah, or Mr. Trush. So,
okay.
Yeah, that'll be within Mr. Thompson's.
Thank you, Your Honor.
Okay, thank you.
And I have Mr. Woods here.
Okay. People versus Dennis Woods, file number 235201.
Sierra Coke on behalf of the people.
It's just a matter with Ms. Adam Brennan on behalf of Mr. Woods, who's present standing to my right. I know the court had rescheduled this matter for us at 9 o'clock this morning, and we appreciate the court doing that. Mr. Woods had difficulty getting here. He was going to be here last night, but things changed and he had to drive up this morning. And was as a result of that, he was late. He got here at about 9:30. We've been talking about it since then. So we do appreciate the time the court has allowed us to do that.
Okay.
Based on that conversation, Mr. Woods has decided to take advantage of the plea offer that Ms. Coke had made him, that had been reduced to writing and provided to the court with signatures. It's pleading guilty to one count of fleeing and eluding as a third degree first offense, and resist obstruct a police officer as a first offense. Dismissing the remaining counts and the remaining habitual offender enhancements.
Okay, thank you. Mr. Woods, have you had an adequate opportunity to speak to Mr. Vernon about this plea agreement? Is that how you wanted to proceed today? Can you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you for your hand. Mr. Woods, are you currently on any kind of probation or parole? And you understand that by pleading guilty to fleeing and eluding, that is a crime that carries with it a maximum possible penalty of up to 5 years and or $1,000 fine. And that resisting or obstructing a police officer carries with it a maximum possible penalty of up to 2 years and or a $2,000 fine. You understand that? Yes. With those maximum possible penalties in mind, what is your plea to each of those charges today?
If you want to accept the plea, you say guilty now, yes.
Guilty. Okay. I'm going to go through your rights with you. You do have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you here at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf here at trial. You have the right to remain silent during a trial and to not have that silence used against you. You have the right to testify at a trial yourself if you want to. You understand all those rights. Yes. You understand that you're giving up and waiving all of those rights by pleading guilty. Yes. Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. You understand that? Yes. Has anyone threatened you with anything to get you to plead guilty? Has anybody promised you anything other than what we've talked about here in the courtroom today? Is it your own free choice to enter this plea? Yes. Are you pleading guilty because you are in fact guilty of these crimes? Yes. The information I have indicates that this happened quite a while ago, 3 years ago, back on October 28th of 2022. Is that the correct time frame? And back on that date, were you operating a motor vehicle here in Crawford County? And it looks like it was somebody from the DNR, Department of Conservation officer that you encountered, is that correct? Yes. And did that officer give you some type of signal, whether that was lights or sirens indicating that they wanted you to stop your vehicle? Yes. And did you fail to do that? Did that result in some type of accident or collision? And what did you do to resist or obstruct that officer as part of that incident? Right. Okay. And did that officer give you some commands to stop running? Ms. Koch, are the people satisfied with the factual basis?
Yes, Your Honor.
Can I ask one, just to clarify?
Sure.
Did you hear a police officer tell you to stop? When you get out of the car and tell you to run? Okay, all right. I'm satisfied. Thank you, Your Honor.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on record?
Yes, Your Honor.
I'm
sorry, no, Your Honor.
As I always do with my clients, I went over his guidelines with him. We spent a lot of time on that. You know, that was very important to Mr. Woods. So my scoring of his guidelines certainly has had an effect on his decision whether to accept this plea today or not. I did advise him that my scoring of the guidelines is just that, my scoring, it's not the court's, and the one that he should rely on is the one the court does later. So I think that that's clear to him that he can't argue that he's relying on that as part of his plea.
Counselor, either or both of you satisfied that the court has complied with statute for will and take this plea?
Yes, Your Honor.
Yes, Your Honor.
Mr. Woods, the court finds that your plea is knowing, voluntary, accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea as to both. We'll set this matter for a sentencing hearing. You'll be notified the date and time of that hearing. It's important that you stay in touch with Mr. Vernon. It sounds like you've been in good contact with him. It's important that you continue to do that until that next hearing. Before you leave today, you're going to meet with Mr. McFell.
Yes, Judge.
With Mr. McFell from the probation department. So, and it's important in a condition of your bond that you continue to cooperate with that pre-sentence report process. Okay.
Previously, the court has allowed Mr. Woods to appear by Zoom for several different hearings to make it clear that he's expected to be here in person for sentencing.
For the sentencing, yes.
Thank you.
Thank you.
I already am working on that.
Okay, do you need the information?
I think I have it, but I'll take it because if I don't, I'm wrong.
Will you let me know who you order it from for the copy as well? Thank you.
Mr. Vila, were you ready on Mr. Letson?
I am, Your Honor.
Spoke a couple minutes early. You ready on?
Yes.
We'll call people versus Letson. This is file number 255389. The records reflect that Mr. Letson is present here in the courtroom today. And this is the date and time set for sentencing in this case. Mr. Letson, did you have a chance to go through the pre-sentence report and talk to Mr. Vila about it? Mr. Vila, are there any corrections in?
No additions or corrections, Your Honor.
Ms. Cope, do
No.
you have any victims that wish to address the board today?
She is present today. I don't think she wants to speak. She did do a victim impact statement to the court, but if she wants to add more.
So, Ms. Radley, is that correct?
Yes.
Yeah, I did read your statement. I know you indicated there that you're nervous about speaking, so you don't have to do that, but I want to let you know I did read your statement.
Thank you.
Ms. Coke, anything by way of allegation?
No.
Yes, Your Honor. Just that I think that this case was largely prosecuted based on my client's prior acts, 2013 and 2012, I believe, domestic violences. They were over 10 years ago, which is why, of course, this was in felony court. My client had totally turned the corner from that time. He's not a violent person. He has a long-standing relationship with Ms. Rapley. They have a child in common, and they have no history together of domestic violence. And so this was a situation where Ms. Rapley was suffering from a mental health concern. She was not on the proper medication that she needed to be on, and my client didn't handle it well. There was some arguing and some jostling, as we talked about during the taking of the plea. Now, the PSI still talks about some violence. I just want to make clear on the record that there's no record of an admission of assault or violence. Ms. Rapley denies it. My client has denied that from the beginning. This is a true case of disorderly jostling, where the police accounts of going into the house and seeing my client up at Ms. Rapley's ear and kind of speaking loudly to her. That's what this was about. So this was an argument between a husband and wife that got a little bit out of hand, not to the level of physical violence, but something that my client does regret. And he vows now to do better in the future. And I think he has some things to say, but at the end of the day, we're asking that you follow the recommendation in the PSI.
All right, thank you. Mr. Letson.
Yes, Your Honor. I made a big mistake by doing what I did. I regret every minute of it. I love my wife. I love my daughter. We are a close-knit family. We've done everything together. We've been together for 12 years. And I believe I was in the wrong by taking it the way I did.
All right. I read through the report. Obviously, as I said, read Ms. Rapley's statement. And I certainly have some concerns, Mr. Letson, okay, because of your past history. There's been a number of issues with domestic violence in your past. It's been my experience, and I think from a clinical standpoint of research, that domestic violence tends to be a recurring and cyclical type of crime. And people who tend to engage in that kind of behavior have a tendency to engage in that over and over and over again, unless and until they get help for it. It's also very common for victims of domestic violence to feel bad, to be concerned about the effect that the offender going to jail or being charged with crimes is going to have on the whole family. Sometimes they feel it's easier just to let it go. So just kind of sweep it under the rug, and sometimes to blame themselves for what happened. And I feel like there's some of all of that going on here. And I think regardless of what happens in this case, that it would be well worth your time to get some counseling. And for you, Mr. Let's get some therapy to address that. Because the more that you come before courts, the less chance there's going to be that we're going to say, oh, this was just something that happened. And the more chances there is that you're going to spend time in jail. And I'm certainly not going to forget that you're here today. And I understand that completely. So it would be in your best interest, your family's best interest, your child's best interest for all of you to get some help. Okay. I think given the circumstances here, you know, the resolution, I think makes sense, and I understand why it is what it is. I think burden is in this case. But again, I think they're in your own best interest. That's some work done amongst yourselves as a family unit. So the court is going to impose 1 day in the Crawford County Jail for 1 day served. Crime victims assessment amount of $130, court costs of $325, $50 state costs, and a fine of $500. You do have the ability to seek an appeal of this sentence because this is a misdemeanor. There is nothing that's going to be provided to you in writing about that, but there are time limits. You and help you to the extent that you want to do it. Otherwise, before you leave today, please go next door to the clerk's office, make arrangements for those fines and costs. Let's go.
No, thank you.
Nothing further. Thank you, Your Honor. Your Honor, and I'll take your advice. Yep, thank you. Thank you, Your Honor.
You are paying and will be there momentarily.
Thank you. Yeah. All right, that concludes our hearing for this morning. We'll be in recess until 1:45.
That's it for today, ladies and gentlemen. I'm going to go ahead and call this one. I will see you guys tomorrow on the next one. So you all have a wonderful, wonderful evening. Ta-ta and ciao, ciao. And I will see you guys again soon.